First you need an injury that is of any type of size. Maybe you're bouncing for $24 or a $90 million prize. Now you need to go find a court that has personal jurisdiction. Article 3 gives a maximum power, so understand the restrictions. And Pennoy one was not in personam, so no it is for that state. Schaefer and Heiner said that it was done with international shoe dictate. Standard defenders and substantial justice on what a culture now act, and make sure that you don't forget these two rules. Remember minimum contacts. Be careful of your defendants' jurisdictions, a right that you can waive. Carnival's form selection plus irons 37B to A. A court with jurisdiction that's general, you can bring up a claim for idea. Individuals must look at domicile, or corporations must look at year.
For here, the state of its incorporation and also where headquarters lie. For unincorporated non-American domicile of members apply. If none of these fit, then it must be specific. Remember minimum contacts. There is also purpose for availment that's not just paying your fair tax. Losing some fingers might cause you to sue some international manufacturers. Lest they advertise in your home state, you'll lose us back entire assures. In Bristol, you need an affiliation between the claim and your home state. If you're driving up onto Oklahoma, then reasonableness dominates. Even with minimum contacts, reasonableness can always outweigh. Burger King contractor Asahi Metal, the course of the state to fair play. Now you just find a code with jurisdiction that only covers personal. State courts don't care about subject matter, but look closely when it's federal.
The U.S. Constitution has laws mistreats or game under 1331. If that's the case, it must appear in the face of complaints that Motleys could have won. Aside from the federal question, there's diversity by 1332A, where citizens of different states and countries must score more than 75K. Citizenship is your domicile, that is where you intend to return. Mississippi or France, you should not take the chance in newspaper your years of concerned. As long as one party spent 75 X on shows that the West do not need to. For 1332C, her and their French show definitions with you has agreed to. Once you think that you have just found a good code, now go serve notice to your defendant. Follow the statute of specific court rule and remember it's due process dependent. Without there, a total due process prescribes that you can never be served in the state. Unless publication permits that such, then you hope that they respond too late.
Berman is fine, but Melania signs that there shouldn't be classifications. Notice be adequate and out of private agreements posting outside the location. If you have any questions, just look at Rule 4, Section E, serves those in the U.S. After Omni Team 4K, international parties can be served with address. You finally serve with the right jurisdiction. Now get used to your courtroom, but don't get attached with removal, dispatch, or transfer to a whole new venue. First off, venues where your case could be brought governed by 1391B. Defendant's home state, the place of the claimant's personal jurisdiction is key. Venue's location that you can transfer, but you keep the law of the old court. Fair and defensive, but properly brought. 1404 lends a hand for support. It's about convenience and substantial justice and where a case could have been brought. 1406 gives the court's discretion to transfer if mistakes are caught.
If the form super inconvenient for one, non-convenience will now apply. A plane crash in Scotland and Wayne whose home dismissal things will go awry. Defendants who don't like the state they're in can 1441A their way out. That kind of pillow claim can create complaints as federal issues they are about. You can't bring diversity with Section B, but we'll move into a defendant state. Section C, that's the split between 1446 as a time frame and procedural traits. Congratulations on now finding a court where you can finally bring forth your case. Now brace yourself as we look at your claim and what is on the pleading's face. Court pleading for pleading and notice pleading are always how you can bring suit. In the federal, then stick to Rule 8 short and plain for fair notice not moot. Back in Spherkievich, everything you don't pitch since discovery can yield new facts. Since Twombly no equal, it better be plausible based on how we think you should act.
No need to plead good faith, Gomez and Rule 8 since that's an affirmative defense. You can plead facts contradictory, acts that make court makes reasonable pretense. If your lawyer does suck, then you're out of luck. There are sanctions under Rule 11. Do your homework and make sure not to delay or else you'll face Section 1927. If they don't want to answer, then look to Rule 12 for there's plenty of motions to hate. Section E1 and clear on F and severe 12B6 for a failure to state. If you do make this error, you'll be able to save since Rule 15's on from amends. A1 lets you act fast, A2 needs consent for peace for after pretrial ends. Now don't be a sluggard and try this too late if you want to aim and to add more. Worthington's Whisk got stopped by Rule 15C since there wasn't a mistake entered for. Once your case starts, it can be dismissed if it was already litigated before. With res judicata and collateral estoppel, your cases are precluded for more.
The Folks claim conclusion that cannot be fudged even when clothing prices are fixed. As long as they're of the same operative facts, new cases cannot be mixed. If you have many claims, bring them all at once, unlike Davis's Dar to Doom. An exception is when both claims can't be first heard in the county of Sawyer courtroom. In California, there are primarily white with two claims from the same act. Sawyer has shown they were of like and Joey's as long as of different sets of facts. Issue preclusions, a whole nother type where decided facts always apply. Federal tribunals count just as much like trademarks gone awry. A kangaroo court cannot render a judgment despite the widest will try. In Taylor, you can't get your day in the court, so here privity doesn't fly. With hosiery and sexual wanted to check, so Meyer this whole debacle. Even though Joey the coat didn't worry, okay, defensive collateral stopper.
Improper jurisdiction and faulty notice or judgments that need not apply, but all is decided even if really long full faith and credit can't buy. If you're going from state court to federal, more Rusty knows they won't bend their backs. Just look at the state law's preclusion rules and ready your collateral attack. If one claim is not enough for you, well, you can bring some more. Just make sure to read Rule 18A where you can add them galore. Of course, the jurisdiction limited by Section 1367A. Same goes for Rule 13 counter claims compulsory permissive the same. Ignoring compulsory will bar you from suit for permissive issuance, and next time, Jones had to learn the hard way that for these supplemental is fine. The difference in crossings for Rule 13G as long as they were like transactions. Like in Almond, you will first dismiss on the merits but not jurisdiction.
Say you have two claims in federal court, one's proper but the other was state. If jurisdiction's out there, it could be supplemental and added to the federal slate. Section 1367A grants jurisdiction as long as they're part of the same case. United Mind Workers from a common nucleus of operative facts that gives embraced. B limits was given up above, like parties joined under Rule 19. Claims by Rule 24, defendants joined by 20 or even 14. All ones was unaware well will work by maintaining diversity is key. 1367C lets the courts choose at the discretion of jurisdiction should be. Now that you added claims, you can also join. The more the merrier. Rule 19 is compulsory. If your lack presence would be a barrier. If a crack at your back, no need to sue both manufacturer and doctor at once. Since Temple shows that to join torture fees, those unnecessary to both confront.
Through all this, just remember that personal jurisdiction is paramount. You can pass 19A1B but fail 19B since Hell's Book takes all into account. If the court isn't clear or whether or not you are there, you joined, you can be permissive. For Rule 20A with a common act in question, your defendant must be submissive. When defendants feel like they're left all alone, they can impede a third party to suit. Rule 14 federal, but don't bank on indemnities and state claims make federal one moot. If you are a third party not brought by a son, sometimes you can intervene. Rule 24A, since you're fencing by right, will be permissive for what the court deems. For 24A, you need interest but disqualified if authority were presented. Then join the case if otherwise you're impeded, like Stardust said as the land is presented. If these parties are still not enough for your case, then maybe you should form a class action. Just read Rule 23 sections A and then B, then note so only need traction.
For Section 8, you must satisfy these requirements, numerous and common to all. Typical of them and representation that's fair and adequate protocol. Then you must choose B, either 1, 2, or 3 to show what relief you want. 2 is for injunctions, for 3 is individual, but here notices pay up front. And then Walmart you won't pass it with them come an injury even when you may need discovery. Then 4B you'll fail on predominance and come cast back models about recovery. By the way, you can waive arbitration class action if you include it in a contract. You can also require only arbitration so AT&T is left intact. And while your fees ought to be a key goal, don't be greedy like in Pearson's case. Rule 23H says be reasonable, taking 70% is a disgrace. Congratulations, you can now start your case and get down to the litigation. But in federal world, you use state law, a question of greater affection.
Let's go back in time to 1789 where the founders said use state law. The rules of decision Act 1652 says all but what Congress has drawn. In 1840, use of said stick to statutes or general federal common law. The 1938 Erie dictated that this term is henceforth outlawed. It curves over anti-discriminate citizens who didn't lend time to hand. So make sure it's stateless, it relates like clear federal spell checks or the band. Now, Erie was Berkey, so later interpreted by many a proceeding case. Your wasn't guaranteed to outcome determinative, substantive, and procedural erased. Then Bird employed a balancing test for fundamental characteristics. Juries are so important to courts' outcomes that the only logistic. Then Hannah's car crash went and led to a case saying Erie had training goals. Make sure to avoid forum shopping and any inequitable control.
your laws all set and you're ready to start conducting discovery, or deposing examinations and written interrogatories. Rule 34 is for requesting production. Rule 37 make sure it's compared. The 26B is for the scope and the limits. It's generally broad and apparent. The general rule is you pay when no question unless you go super lucky. You do it just one if too burdensome. The requesting for you isn't free. Sometimes you can ask for too much if it's privileged and you are denied. Absolute can only be pierced with a statute where the court can decide qualified. Upjohn World got rid of the control group test. For attorney-client, the privilege is set for all employees at West. Your work product privilege is quite a bit different and operates in a sporting way. Hickman was lazy and wanted his notes, but was privileged to his dismay.
Expert will choose before gives 4 types of names for some you can find, but if informally consulting and reading iconos is a privileged kind. If you bring a case needing an examination, you may be compelled to have one, but Vincent can verify you still have a right not to divulge everything you've done. Before or after discovery, you may be sick of arguing your case. If you want things cheaper with speed and certainty, then settlement you'll embrace. Rule 16 governs pre-trial meetings and lets the judges promote settlement, but in court you speak, appeals can comply with compelling and to the detriment. If the defendant offers you some money, make sure to read Rule 68. If you don't take it now and the judgment is less, you pay their fee starting from that date. Without a settlement, your case can end early through something called summary judgment. If the facts are all true and it's a matter of law, then you win without argument.
If you move for this judgment, then you'll be assured you don't need to put evidence in play. Against other text and consequence you say, the board just shifts away. Since this is governed by Rule 56A, make sure it's a matter of law. You're told and be caught in the judge wrongly rule based on what the cop said he saw. Deciding this issue is a question of fact which is left up to jury decisions, but sometimes a judge can dismiss their findings and insert instead their own visions. Rule 50B talks about J&OV, where you look at facts favorable to the plaintiff. Simplest was so while the judge couldn't go along and rule properly on this tiff. If there are facts that could be construed differently by a reasonable mind, then in suicide the judge can't acquit thee, thus the jury's decision binds. The jury could also give out too much money like they did in Ogie. So we met a Turk says you better take less or a new trial will come onto thee.
If a new trial was reported for a while, then look to Rule 59A. Either evidence is weak or not yet discovered or procedural errors in fairly straight. For these type of errors, jury influence must be external, because drinking and spliffing and sniffing cocaine are internal, so do not break lies. If you want a new trial, then also please file a motion for J&OV. If the judge gets a second and it is appealed, the first could still come to me.
But if you're a spurian, then you might lose both in thought because new trials are rare. The 7th Amendment says juries are key in the decisions on what you should bear. With all these controversies regarding your jury, sometimes only a judge will decide. For this is Rule 52, where they must publish fact and law, but need to abide. If it's appealed, then a court will apply to the law de novo review. But if Anderson's facts are later attacked, only clearly erroneous will not do.
So finally now you have come to an end, but information you can always appeal to an appellate court. It's a matter of right for Supreme's a discretionary deal. Appeal is a right of 91.4, decisions collateral rules 2. Discretionary is mostly interlocutory, restricted to 92. For Rule 54B, it's also discretionary for claimant a multi-claim case. Rule 2.3 extra class action, Rule 165 mandamus is place.
Then Mohawk appeals on that grand location unless you have no other choice. But here they could file on plenty of options to be sanctioned and give up their voice. Mandamus is an extraordinary when only for a clear and indisputable case. The court will court to try against this precedent they couldn't embrace. You finally know how to mount a whole case and to see it all the way through. But be also sure there are plenty more rules. Don't be afraid of them, they won't cause mayhem. You love them and hug them and not want to wait until he takes your photo.